And that case has helped us immeasurably, and principally it helped us about 10 years ago when a case walked in the door. The client had just bought a car wash in a town called Montclair, New Jersey, about 10 miles, 15 miles west of Manhattan. And the car wash was on a busy commercial thoroughfare, and he had put about $2.5 million into buying it and fixing it up. And then, lo and behold, he gets a letter within, I think it was in 90 days after he closed title, saying that they needed to rebuild the railroad bridge that was adjacent to that car wash, and they were going to deny him access to his car wash for a year while they repaired the bridge, meaning that he shut down for a year. It's a total temporary taking of a car wash that someone just put $2.5 million into. And he came into our office and said, what am I going to do? I have 2 mortgages now. I've got labor. How can I just tell them to go away for a year? I still have to pay my mortgage. I got to pay my property tax. I have to keep the equipment that I just spent $600,000 on running so that it doesn't get rusty and ruined. I'm going to spend money on utilities. I need some labor to help me do this, and I won't have any income. And I can't get cars in and out of the car wash until they're done. And I know they say it's 12 months, it's probably going to be 24 or 36, because it always takes longer. So what do I do? And we grappled with this issue, and fortunately, I had the sage advice of my partner, Ed McCurdy, who recently passed away. And he said, well, you got Kimball Laundry. And Kimball Laundry is the law. And he said, but let's do it this way. Let's tell the DOT, who was the taking agency, that their offer was flawed because the offer that was provided to us was essentially a real estate appraisal where they said car washes rent for X number of dollars a month and you get 12 months rent, therefore you get $160,000 based upon a monthly rental for car washes, which that was a low number even for that. But it was rental for the real estate only. So I wrote them a letter before they filed their complaint, and I said, you have either been misinformed or you have overlooked a very significant issue, and the issue is that the state here is obligated to pay my client its business loss. And they wrote back and said, are you crazy? We don't pay business losses in New Jersey. And they filed their complaint. So I raised that objection in the right to take proceedings as being evidence of lack of bona fide negotiations because they overlooked something that was a material flaw in their offer. And the trial judge agreed with us and agreed that Kimball Laundry was controlling law. And then the state said, well, they weren't happy about it because they lost, and we also get counsel fees when we get a complaint dismissed, which is what we did, which is why we did it that way, so we get the counsel fees. They appealed it. We go to the appellate division, and they said the same thing. We don't pay business losses. Look at all this law. And I remember getting up. I wanted to get up at the argument, but I sent my partner Ed to argue it because he had more gray hair than me at the time, and he did an amazing job. And he basically said something to the effect of, these weren't his exact words, I'm sure he was more eloquent than I. He said, the last time I checked, the United States Supreme Court can make decisions which are binding upon this court. And this was 2008 that we made this argument, so it was 60 years after Kimball Laundry was decided, and there hasn't been any law to the contrary from the United States Supreme Court on issue, and this is exactly on point. And we got our decision, and it was affirmed, and I was shocked that it wasn't published, but then I realized why it wasn't published. It's because it's the law. And this court wasn't making any new law. And the DOT sheepishly went back with their tail between their legs, and they had to come up now with a way to estimate the business losses, and they've never done it, ever.